So for our session now on precedent, I brought something like from school, show and tell. Do you have that in Brazil? When your kids take something to school to show people. So I have my own show and tell. I brought a couple of books, and they will mostly be relevant when I start talking, but I think they're already relevant when Teresa is talking. So what I brought to you are a couple of standard practitioner or law school books, and I will just pass them around. I trust that none of you will steal them, because firstly, you are good people and you're judges, but also because unless you are a German or French legal practitioner, you will find these absolutely dreadful. And that's the point. What I want to show you is all of these German books coming around, they are the kind of books that I, as a law student in Germany, we had to use those, and every legal practitioner in Germany will have this book on their desk. This is basically like a Bible for the civil law. I also have for criminal law and administrative law, and they exist basically for every area of the law. Well, you'll see. It's and this is what you look stuff up with. And then you look something up. It's organized by the articles of the code. But then what's in there is basically references to precedents. And that's what I want you to see, that it's full of these references to precedents. I have two of those about civil law, the big ones. Then I have a small gray one about criminal law, and an orange one about civil procedure in Germany. And then I have a blue one from France, corporate law, same thing. And then I have, just as a counterpoint, I have this one, exactly, that Orlando was holding up. That is, it's not about precedents, this is statutes in the United States. This is what we force our law students to buy when they take classes. And in this book, there's nothing in there but statutes. Now, I will say in fairness, in class, we mostly discuss cases, but, that's just because the way we organize our classes. But that's actually, the statutes is what you need to know as a common lawyer, just as you would as a civil lawyer. So I just pass these around. You can take a look as long as you want or not, and we'll have our discussion up front.
Of course. Good morning, everyone. Thank you for attending this panel. And I'm very proud of the Brazilian judges, because at least Professor Holger has no evidence that Brazilian judges don't follow the precedents. Am I correct?
Not yet.
Maybe even do. Maybe, there is a difference in the right direction. So,
Okay, but at least we're in a good situation here. And now I'm gonna pass it over, given that we're running late, to Professor Teresa, who is a brilliant professor of civil procedure at the Pontifical University, Catholic University of São Paulo, and also the vice president of the commission who was in charge of drafting our new code of civil procedure, which tried to implement a system of binding precedents in Brazil, right? So please, Professor Teresa.
Well, good morning to you all. I'm very honored to have been invited to this conference, to be part of this group of excellent professors, of brilliant scholars, and to talk to this highly qualified audience. And for that, I thank Professor Eric Navarro. And I promise you that I'll try not to read, because it's really very boring when one reads the whole presentation. But I'm going to read sometimes, because it's not my mother tongue, so I'm always afraid of making mistakes and of disrespecting a language that I love. Well, I was asked to say something about the way Americans and Brazilians deal with precedents. I know it's very dangerous to say something about comparative law. In fact, comparative law is a very difficult field. Several truths have been repeated all over the world in the very same way for centuries, and they are lies. But even so, I will try to say something on common law countries, especially about American law, and to describe how things in fact happen regarding judicial precedents in our country. And I say in fact because, as you all know, in Brazil, we teach and we work. And this is a joke because normally students ask us, Professor, do you only teach or do you also work? It's real, it's the reality. So in Brazil we have, normally we are judges and we teach, we are lawyers and we teach. We have 2 jobs, at least. Well, and to tell you the truth, I do think it's very good. I think that it gives more lucidity. I think that a brilliant scholar can be even more brilliant if he has some contact with the practical world. Well, judicial precedents are one of the 2 main sources of law in Anglo-American legal systems. Constitution and statutes make up the other. In civil law legal systems, jurists interpret statutes. They try to determine the meaning of their language. But when a judicial precedent has to be interpreted, analyzed, one has to go far beyond the judge's words. Sometimes, as is well known, several factors come into play when judges resolve cases, even some which are not strictly legal aspects, as Professor Holger said. Frequently, they are not explicitly dealt with in the decision, but in interpreting a precedent, these factors have to be grasped or understood to clear the path for us to grasp, for us to get to the ratio, to the ratio, what, as we say in Portuguese and in Latin, probably. I always think when the English say ratio decidendi or stare decisis, if the Roman had this accent, probably not. To stand by things decided and not disturb settled points. This is stare decisis or stare decisis, the legal doctrine that commands deference to precedent. The decision must have been rendered by a majority of the voting judges on a question or issue of law to be considered a precedent. Usually the decision must have been published, and, of course, the court must have decided the issue to solve the dispute, not as a dictum. Some say that the Anglo-Saxon system of binding precedents is a universal manifestation of human nature. What is, in my opinion, a universal manifestation of human nature is the need for predictability, which implies naturally stability, uniformity, but not the system of binding precedents itself. Law in Anglo-Saxon legal systems, when facts are governed by common law and not by statutes, is created by judges. They say judge-made law. Law is in fact discovered in the decisions. Principle applied to solve a dispute once should be the basis of future cases, at least they should be, which are either identical or similar to the previous case. Deciding according to precedents is, in my opinion, in fact, the most natural way of providing equality, predictability, stability, and uniformity, but certainly not the only way. And I say that because historically, our system, civil law systems, had the same goal in mind when our method of judging, of deciding, of hearing cases was conceived. These are, in fact, also the goals of civil law systems. And historically, as we all know, we have chosen a different path. I do think that the real origin of civil law systems, as found today, is the French Revolution and its underpinning principles. Civil law countries inherited substantive rules from Roman times, but the basis of our reasoning style arose in the Enlightenment and was reflected in the politics of those times. In fact, since the 17th century, abstract reasoning had characterized the French approach to law and indeed to life in general, to everything. Montesquieu's theory, in the sense that there should be no over-concentration of state power in the hands of one individual, was married to a Rousseauian concept, and I love this expression, was married to a Rousseauian vision of statute as expressing the volonté générale of the French nation. The idea that the central power was justified or legitimized by the people's will was one of the most important ideas which inspired the French Revolution. Thus, judges were to obey the law, to decide cases strictly according to the law. Decisions were always reasoned, and explicit reference to statutory law had to be made. Judges were, in fact, seen as inanimate beings, the mouthpiece of law. The deductive theorists were considered to be able to explain judicial decisions as if they were the result of logical reasoning. Law plus facts equals decision. This rigid conception was partly due to an unremitting mistrust of judges held by the bourgeoisie. There was a fervent belief that the people's will was in statutes, was reflected in a very faithful way in written law, and consequently it was admitted that if statutory law was obeyed, was strictly and literally respected, the people's will would be respected too. The system which first existed and was abolished by French Revolution, le Ancien Régime, gave too many privileges to nobles and clergy. The peasants and the bourgeoisie were openly disadvantaged. In addition, judges could be, and they were in fact, strongly influenced by powerful people. So the upper classes and by the upper classes, and this might lead judges to decide in their favor. So, and this is very important, of course, the absolute rigidity of written law was then considered preferable to the freedom of interpretations by judges. A connection, a very intimate connection, was established between written law and equality, for it was considered that when law governs, equality is granted. In fact, the principal ideas embodied in the legislation conceived during the French Revolutionary period were liberté, égalité, et fraternité. These ideas were reflected in statutes, and courts were supposed to apply statutory law to the case at hand. And, very important, never to lay down rules, general rules for other cases. According to an old, historically justified conception of civil law systems, this regime was governed by putatively comprehensive legal codes. That means exactly that there was an idea in the sense that codes would be able to comprehend the whole reality. And so everything that would take place in real life, every possible problem or dispute between the parties, would have the answer in statutory law, the exact answer. All judges had to do was to find the facts of the case and apply code provisions to these facts. So, the responsibility for creating a rule for future cases theoretically should not bother a civilian judge. For individual judges have the freedom to interpret statutory law according to their own understanding or opinion. But obviously, as we all know, conditions of modern societies are completely different. They imposed a new vision of this phenomenon. The world in which positivism was born no longer exists. Contemporary societies are much more complex. There is a strong inclination in the contemporary world to include all social levels into institutionalized society. Even social levels which in the past would have been at the margins of civilized society. This is probably the most outstanding feature of our times. The social mobility has exposed in a very evident manner the difficulty in operating a system based exclusively on written standards or deductive reasoning. Furthermore, access to justice, which was an old and traditional dream of jurists, is actually becoming a reality. And that means that the way civil law was conceived at the beginning, at its origins, could maybe work because reality was big like that, and the facts which were brought before the judiciary were like that. But now reality is like that, and what is judicialized is like that, almost the same size. So it's inevitable that that the situation had led to an increase of the complexity of cases brought before the courts. The complexity of real-life situations in contemporary societies has led philosophers to the inexorable conclusion that codified law is not enough, literally considered, that statutory law is not an entity endowed with, how the Germans say, logische Geschlossenheit. That means it's not closed in itself. Sometimes judges have to make decisions according to the particulars of each case. That means there has to be to some extent, flexibility. Statutes are nowadays written with broad language, so vague norms are frequent, and also general clauses and legal principles usually play a very important role in legal reasoning. Decisions in civil law jurisdictions can no longer be seen as the automatic result of the application of statutory law to the facts of the cause, to the facts of the dispute. Traditional syllogistic thinking had been shown to be completely inadequate in solving many matters. It is still truth that judges decide according to statutes. Nevertheless, in the last decades, jurists have perceived that judges have a creative role. Not all of them confess it. Some of them really hesitate to accept this idea that judges create law, and there are some who really completely deny it. But there is, in my opinion, a clear tendency, a clear trend to admit that judges are creative. Yes, they create law, even in civil law countries, in different degrees. Normally, when interpreting statutes, the influence of case law in judicial decisions in civil law countries is really undeniable. Statutory law only plays, in fact, a role through the interpretation that has been given by a court. Judges have to decide according to statutes. Judicial decisions must adhere not to statutes literally considered, but to the system, to the legal system as a whole. And it's generally admitted that contemporary legal systems in civil law countries are formed by statutory law, in the broadest sense of the word, legal principles, case law, and legal literature. These are, in fact, the elements from which a judge makes his or her decision. If case law is an undeniable source of law, precedents have to be respected to ensure equality, predictability, and uniformity. Good examples can be given, very good examples in my opinion, where the final legal solution was given by judges. In the first case, interpreting statutes, the first example that I'm going to give, and in the two other examples, second and third, the judge simply applied legal principles, not statutes, to solve the case. First example, we all know it, of course. According to a Brazilian act, the creditor cannot seize the family home if this is the only family property. The courts nowadays considered that the word family covers several situations. For instance, grandparents and grandchildren, uncle and aunt with nephew and niece, and even someone who lives alone. The courts intend this act to protect not only families stricto sensu, but human dignity. Second example of judicial decisions, several judicial decisions not based in statutes. Case law also devises solutions for situations not expressly covered by statutory law. normally supported by legal literature, as the French would say, doctrine. A good example of this solution is the adoption of the frustration of purpose theory, or frustration of contract, under the doctrine of impossibility of performance, which operates very similarly to the force majeure theory. A party to a contract is relieved of the duty to perform it when performance has become impossible or very difficult through no fault of his or hers, and the grounds of this impossibility could not have been foreseen. The frustration doctrine in Brazil is applied by the courts even if it's not specified in the contract. And last example, very interesting too, in my opinion, maybe the most interesting of all the examples. Nothing to do with the federal justice, but very, very, very interesting. It's a family case. Sometimes law anticipates a solution which proves to be necessary as a result of alteration in social conceptions. A few decades ago, there was no statutory provision that established duties for two people who cohabited. At that time, courts had already made decisions to protect economically a woman left by a man if they had cohabited for a reasonable length of time. Well, you know all the evolution now of this history of the concubine. In the first, some 100 years ago, she received just a minimum wage for a month, and then the situation of this woman who would be left by a man was completely changed in the level of case law, and then the Constitution was enacted, and the situation was finally disciplined by statutory law. And well, it's a more interesting example would be the gay marriage, a situation which was really solved in the level of case law. It's still being solved in the level of case law, still being discussed, but it's changing in Brazil, and not through the labor of the legislator, but through the hands labor of judges. I prefer to say that these elements, statutes, precedents, and legal literature, form the legal system. In fact, in my opinion, they are more than mere sources of law. They are law, in fact. And now coming to our new Civil Procedural Code, and coming to my conclusion, of course. I think it's very interesting to analyze our new Civil Procedural Code and to perceive that it admits in a very clear way, in a very open way, that judges create law. That judges create law is widely recognized by our new Civil Code of Civil Procedure enacted in 2015. Because there is a provision orienting judges on how to write or to draft a decision when its basis is a precedent. That it's completely admitted by our legislator that judges can base their decision on a precedent. It's also possible to file an action to vacate an unappealable judgment when it is based on a precedent which really did not apply to the case at hand, which was completely inappropriate, ação rescisória. But the new Brazilian Civil Procedural Code deals with precedents also in a very Brazilian way. In fact, and this is derogatory, of course, unfortunately, I think, because it's not really dealing with precedents. What our new code does is using the precedents when facts are not just similar but identical to solve a problem of case management when it's the case of mass litigation in some special situations where there are hundreds of pending cases where the same question of law which is discussed is exactly the same, statutory law allows just one appeal to be heard as if it were a sample, which will be a binding precedent on contemporary pending cases and also on future cases. That means, in fact, in this case, deciding according to precedents when facts are identical is a method of dealing with mass litigation. On the one hand, what the legislator did, in fact, was to use these precedents and their binding nature, now formally admitted by our Civil Procedural Code, as a tool to exert case management in the sense of dealing rationally with mass litigation, with cases involving identical questions of law against banks, against the state, against telecommunication companies, etc. On the other hand, the new code has several provisions advising courts to produce uniform, harmonic, coherent case law, which should be respected by hierarchically inferior judges. Of course, some authorities criticize very deeply these provisions, and also those which create binding precedents under some conditions, saying that separation of powers would be compromised, that judges could not create law, that judges must just decide according to the law, but not create law. Judges' freedom to interpret its statutes is in fact considerably limited in these cases. And this is rather explicitly stated in various statutory provisions. We obviously do not agree with these authorities who criticize this trend, because in fact, civil law systems were conceived, in my opinion, they were almost rationally conceived at some point of history, with this main aim of creating predictability. If all judges could take decisions according to their own opinion or understanding on the real meaning of law, this goal would never be achieved. Nevertheless, in Brazil, we still work in a very rudimentary manner with precedents, using precedents as a tool to control mass litigation, creating a rational method to resolve identical cases, according to a first precedent, normally the decision of a superior court. And I say that it's rudimentary because sometimes the way Brazilian judges deal with precedents reveals they are still addicted to deciding according to a predetermined rule. Reasoning apparently does not begin with facts, what happens in common law countries. A good example is the way they act when deciding an appeal filed before a superior court, when resolution will determine the way in which 200 or 300 other cases, 2,000 or 3,000 other cases, identical cases, will be resolved. Mass litigation. Before, this is about the recursos repetitivos, this is only for Brazilian people. Before the appeal is heard, judges write down what they call a thesis, the issue of law underpinning the case. They write the thesis, and then the case is heard, the case is decided. Conversely, the work of common lawyers do with precedents begins with the analysis of the facts of the case and not writing a thesis before the judgment of the appeal, as they do in the STJ, in our superior courts, STJ and STF, STF and Supreme Court and Superior Court. But, and now I'm coming to the end, there is also a trend nowadays, and I feel it, and I think it's a very good sign, to deal with precedents in a more refined way, which reminds one of the way common lawyers do so, or at least should do so. This means deciding according to precedents, even when cases are not identical in what concerns facts. To decide according to precedents when cases are not identical, as it happens in the repetitivos and in the IDR, necessarily requires arguing by analogy. For example, if a court decides that a commuter benefit cannot be paid in cash, but must be given to the employee in specie, these precedents will probably provide guidance to a future case where the point of law would be the possibility that the meal voucher be paid in cash, and the facts are not the same. But this reasoning is not appropriate to all these mechanisms created by our new CPC to deal with mass litigation. In this field, cases must be absolutely identical. So, allow me to conclude, and I know you will, to deal properly with decision-making according to precedents, even with those derived from statute, takes time and requires care, attention, and refined reasoning. Unfortunately, our numbers are huge. We have 120 pending cases in Brazil. Our Supreme Court hears 300 appeals a year. So, these are two obstacles to working correctly with precedents in Brazil. 2, a judiciary with little time, first, and old civil law habits, a real addiction. Thank you very much for your attention.
Thank you, Professor Teresa.
I'm going to use this one. Can you hear me? Because I'm like a tiger in a cage. I like to move. Okay. Teresa and I, we exchanged our views before we were going to speak, and we discovered that we basically agree. So I will try to tell you a little bit more about how things work in the United States, but then I will also try to perhaps emphasize the points where we might disagree, where we might have a different perspective, and then because that will then allow us to focus on what really matters and where we have things left to learn. So just to start by way of background, so I'm originally German. I studied law in Germany and in France. I have French and German law degrees. And I took comparative law with one of the biggest people in the field, with Hein Kurtz, who was then teaching at Hamburg. And Hein Kurtz has, if you've read his books and his articles, he has a very, I would say, he doesn't see very big differences between common law and civil law. So he would never say something like that there's no precedent in the civil law. He would never say that. And yet, when I came to the United States, I expected to see some differences. And in my first year here as an LLM student, I was thinking, this is weird. This is just the same as in Germany. What's the difference, okay? What's, what are they all talking about? And now I've been here for 15 years, and I would still say, what are they all talking about? I mean, there are some superficialities that we can talk about, like the way the opinions are written, for example. That is a difference. Whether it's a meaningful difference, that I think we do not really know. Some details about how the laws are organized, like these books I've passed around, I will say they're really good, and I wish we had them in the United States because of just the way the profession is organized. Good people in the United States don't make the kind of books that you see there. We have such books, but they are produced by the third-rate people, and so they are just not as good. In Germany, the first-rate people spend their time doing these books. Maybe that says something about German character, like writing boring books. Anyway, that's what they do. So what I'm going to do now, I'm going to talk a little bit more about my experience in the United States, but a little bit also in Europe, and hopefully then we can compare experiences, and you tell me whether Brazil is also the same or whether Brazil actually is different, as I've sometimes been led to believe by Brazilians that I have talked about. One thing I should say right away, when we talk about precedent and how it's used, we have to be really careful to avoid the myths that Teresa was talking about. The myths that you I'm sure you know, no precedent in the civil law, as I've tried to demonstrate with these books I'm passing on. That is surely false, totally false. The other myth is that precedent and common law systems operates in this hard, rigid way. The case is decided, and then that's it, stare decisis. Moreover, we know what the case stands for. It's the holding in the case, and we can limit it, and it doesn't go beyond the facts of the case. Limited to the facts. Maybe English law in the early 20th century was like that. There are some opinions that sound like it from England. I can tell you with 100% certainty, US law is not like that and never was like that. Never worked that way. Okay, and I'm going to give you some examples about that. In reality, in the United States, cases announce rules. They are not narrow to their facts. They just say, the judge will just say, this is an interesting question. I think the rule should be this. And if it's an important, anytime it's an important case at an appeals court, it's not just one judge, it's a panel of judges, and they will say, or the majority will say, this is it. This is the rule now, because this is how we interpret the law. No limitation to facts. Everybody agrees that that's what the case says. Nobody comes along and says, oh, no, you could not possibly decide this because the facts were much narrower. No, they just decide. I'll give you examples of that. Of course, judges play with precedent. As I mentioned earlier when I talked about my experiments, they talk about precedents. But there's rhetorical devices to get around the precedent, and judges do so very liberally. So in that sense, precedent is not binding. Actually, oftentimes it gets explicitly overruled. But even if it doesn't get explicitly overruled, there's this old joke about traffic accidents and like rules for traffic accidents. There's an easy way to distinguish any precedent. You just say, well, that precedent, that case involved a brown car of a Ford model whatever, but this case is a red car and it's a Chrysler or something like that. Okay, so and that it's a joke, but it's the joke is inspired by reality because you observe what the courts are doing. And that's not to say that U.S. law is a free for all. Precedent does matter because I think it's just judiciary is self-respecting. They understand that the authority of law rests on some continuity in the law, and judges would be stupid not to follow precedent up to a point. The question is how much, and is there actually a difference between jurisdictions? All right. Having said all of this, let me give you two examples from U.S. law. I try to make this explain what the cases were about. I'm a corporate lawyer, so I teach corporate law, teach corporate finance, teach class on hedge funds, so I deal mostly with corporate law cases. So I'm going to give you an example from corporate law, decided a couple of years ago here in the United States. Our corporate law is state law. There's one state, Delaware, that is the state for corporate law, so it's a Delaware case. The case is called MFW, and what MFW does, it addresses what we call fiduciary duty overlay to the statutory rules on mergers. So a merger, for those of you not corporate lawyers, you take two corporations and you fuse them into one. It's like procreation of some sort. What happens when the eggs fuse, and then you have one corporation, and we use this for all sorts of things. We also use this to what's called squeezing out minority stockholders. So if you are a controlling stockholder and you have some, 40% minority stockholders, you don't like them anymore, what you do is you set up a second corporation, you merge them, and in the merger, the minority stockholders get cash, and you stay as the only remaining stockholder. It's called a squeeze out, and it's being done. It's a very common thing to do. And under the statute, the rules are very easy. The rules just require that there be a board resolution, that the corporation's board approve the transaction. Well, the board, of course, is elected by the controlling shareholder, so that's easy. And then the shareholders have to approve by a majority vote. Since the controlling shareholder has the majority, that's also easy. And then we have our merger, and the minority shareholders get cash. There is a statutory remedy for them to complain that they did not get enough cash, but it has certain procedural difficulties that make it an unattractive route for them to get money. So the real way these mergers are being controlled is through what's called fiduciary duties. And fiduciary duties, I don't want to get into the history and so on of this and the etymology, but think of it like something like a good faith requirement. That's, I think, the best analogy in the civil law vocabulary is a good faith requirement that the controlling stockholder has to behave in a fair manner towards the minority. What is fair? Well, that's complicated, and that's we don't really know until the courts tell us. So what did MFW do? MFW said, well, if you do the following, you put together a special committee of the board of independent directors, they negotiate the deal and they approve the deal, and then you put it to a vote and you require that a majority of the minority shareholders, so not the controlling stockholder, but the majority of the other stockholders approve the transaction, then we are going to consider this transaction fair, and so then the minority will not have a judicial remedy against this transaction. The decision said this, and it just said this, and we all accept it. And now when this comes up again, nobody says, well, I don't know, that case was a construction company, this is a so-and-so company, that case had foreign shareholders, these ones, it doesn't matter. No, we have a rule now, and the rule is, if you do these two things, then it's fair. The thing that the courts still do look at in the individual case is, well, this independent committee, how independent were they? Because it's tricky, you know. People have all sorts of contacts in life, and if a rich guy says, to you, says, hey, do you want to join the board and be on the independent committee? And you say yes, and then you're on the independent committee and you have to approve the transaction. You may think, if I go against the rich guy, I will not be called again next time to be on this committee. And it's nice to be on this committee because they pay me $400,000 a year just to be for a couple of weekends of my time, So it's tricky, this independence thing, and the courts do look at that in a factual manner. But it's not because they are concerned about the content of the law as it was announced in MFW. It's because they still have a close look at the facts. If you will, the rule of MFW, independent committee, contains a vague term, independent, which does get flashed out in every individual case according to the facts in that case. So MFW announces the rule, that's it. There was one question mark. This was announced in the context of a squeeze-out merger. Controlling shareholders do other things where we have a conflict of interest. Does MFW also apply to those other things? So like half a year later, we get another decision that says yes. So from now on, we just know, and that's what I teach my class. I mean, we read the case, but then, from now on, we know if you have those two things, then the controlling shareholder is all good to go. Is this unusual? No, not at all. And in fact, it can be much more extreme than this. And I'll give you another example from the same area of law. Sorry, I'm blocking the way. I just can't, give you another example from the same area of law. Before MFW, the biggest case was a case called Weinberger. Weinberger was 1983, and Weinberger was a case where the controlling shareholder really misbehaved. So they did bad stuff. Anyway, in this case, as the court is discussing all this stuff, they put in the footnote 7. It is really footnote 7. I know, because everybody talks about footnote 7, okay? So footnote 7 of the opinion says, this case would have come out totally differently if the controlling shareholder had put together a special committee to look at this transaction. So the opinion comes out, everybody reads the opinion and says, aha, footnote 7, special committee. And from then on, everybody put together a special committee. It wasn't even law, the court didn't even say, I think the words were, might have come out totally differently, okay? Nothing there about law, it's a footnote. It's not, it's not the fact of the case. So it's clearly dicta in the lingo of precedent. But that didn't matter. Everybody understood that that's what the court thinks and will think, and so that's what everybody did. They used these special committees. They didn't get you quite the protection that MFW gets you. That was the difference in MFW. But I just want to emphasize, a footnote in the case was enough to create the very strong understanding that that was the law. Now, on the one hand, this says, yes, we have precedent in the United States. On the other hand, it also tells you it has nothing to do with the folklore of like the narrow reading of the case restricted to the facts. No, courts just announce rules. I'll give you another example. This is from a very different area of law, and I think it's important to realize this. Constitutional law. Constitutional law is different for various reasons. One of them is it's politically much more salient. The other one is that even in the United States, of course, there is a text very clearly from which the reasoning proceeds. That's the Constitution. And the court has the power to select its own cases in the United States. The United States Supreme Court picks the 80 cases or so that it wants to hear every year. They don't need to hear the cases. It's also very interesting. So having said that, the case I'm going to talk about, Citizens United, which was a 2010 decision by the U.S. Supreme Court, in which the U.S. Supreme Court decided that corporations, all corporations, be it a non-profit, for-profit, doesn't matter, all corporations have the right to free speech. And what does that mean, practically speaking, in the United States? Well, it does mean, of course, press releases and things like that, but mostly what it means is giving money to political candidates or paying money for political advertisements and that sort of stuff. So every U.S. corporation has the right to do that, constitutionally protected under this Citizens United opinion. And now the important, let me stress a couple of, this is a very famous opinion. Let me stress a couple of things about this opinion that do not at all match the cliche understanding of precedent. I'll start with what does match the cliche understanding of precedent. Citizens United, as soon as it came out, everybody understood that this is now the law. There is no question, no district court in the United States, not even a state court, would dare decide anything related to free speech differently from Citizens United. Citizens United is the law. So in that sense, yes, precedent works as it should and as everybody thinks it does in the United States. Now, that's for the lower courts. The Supreme Court itself in Citizens United overruled its own decision from 2003. In 2003, the United States Supreme Court in McConnell had decided the opposite of what it decided in Citizens United. And McConnell was not an outlier. Like McConnell itself was based on a decision from 1990. I think it was called Austin. And there were many other decisions that sort of fit this overall picture. And they had said, no, corporations do not have these free speech rights. But the Supreme Court just decided that they're going to change their mind. How do you do that as a Supreme Court? You say, well, McConnell in 2003 and Austin in 1990, they said corporations don't have free speech rights. But there are these older cases from like 1950 or 1920 or something. They didn't say that. And so it's not us today, 2010, who are wrong. It's the previous judges in 2003 and 1990. They were wrong. And we're just correcting the law, and we're getting it back to what the law should have been all along. Okay, so overruling the old precedent. However, what they didn't emphasize, but it's true, these old cases that had come out the other way, they were talking about corporations, but they were talking not about business corporations in general. They were talking about very special corporations. They were talking about churches, newspapers, television stations, so and a couple of political activism organizations. They are organized as corporations in the technical sense, but they are clearly very, very different from Coca-Cola, Exxon, your usual business corporation. Again, the common law folklore, the mythology, would say that those precedents are irrelevant for the question whether Coca-Cola has free speech rights, because those other cases on the facts, they're very different facts, and they shouldn't apply to Coca-Cola. The Supreme Court literally does not care, okay? Literally does not care. Because the majority of the justices, in this case, the 5 conservative justices, they wanted this result, and so they used whatever they could find, and you can always find something. They used something to justify this outcome. Now, is this good? I think it's highly problematic. I am afraid that over time, this tendency of the US Supreme Court to decide these hard cases with a 5-4 majority is eroding the trust that people have in the judiciary. These days, when we have confirmation hearings for Supreme Court justices, it is exceedingly clear that it's all about the politics of the justice. There is some lip service to the rule of law and all of that, but everybody knows that who the judges will determine what the outcome is going to be. And that's problematic because the losing side, how will the losing side accept that outcome if we all know that it's just the politics of the justices that were involved? And, I think, since we are among judges here, I will just say, I think that the US Supreme Court, at some point, many times in its history, has made the mistake of pushing the law too far and claiming that the law is able to settle certain disputes, which it really cannot. Let me give you an example from the other side. Roe v. Wade, the abortion case, 1973. The United States was, to my knowledge, the first Western country, or maybe the first country in the world, to legalize abortion completely. And it did so very early in 1973, and it did so by a Supreme Court judgment. And the United States is today the only Western country where, to my knowledge, abortion is still a big political issue. All the other countries, like Western Europe, Australia and so on, they had abortion debates in the 1980s, sometimes in the 1990s. They reached a political settlement. Abortion is now legal everywhere, even in Ireland now, and it's over. And so I think overall for social development, that was a much better route to take. It took a little bit longer, but the outcome is much more accepted than in the United States, where many now actually expect that if unless Trump gets unelected and something miraculous happens, that with the current majority on the Supreme Court, Roe v. Wade will fall. I'm looking at Lawrence because Lawrence thinks about these sorts of issues, I think. Yes, so you feel free to object. I think there's a big danger that Roe v. Wade will fall, because the legal reasoning ultimately was very, very weak. It was based on very, very broad notions, and that's fine if we all agree that that's the way you want to go. But if a majority of the justices does not agree, then that's an easy case for overruling. Anyway, so that's about the... Oh, one more thing about the U.S. Supreme Court. This is about the thesis, you call this in Brazil? Mm-hmm. No? So every U.S. Supreme Court litigation case starts with, in the briefs, issue presented. And the issue presented is an abstract legal question. And then everything in the briefs is about this abstract legal question. Now, it's true that there are also a couple of facts there, and I talk about the facts, but at least at the Supreme Court level, it is about abstract norms. So I have to learn more about this thesis practice to know whether that's really different from what the US Supreme Court at least is doing. Now, bring it back away from the Supreme Court down to the trial court level. In my area of law, corporate law, Delaware, it's all about the facts. It's all about the facts because the judges, like this notion of independence that I mentioned earlier, of fairness, and 30-day trial with lots of witnesses and facts to determine if something was fair or somebody was independent. That's what trial litigation is about. But at the Supreme Court level, abstract legal questions. So if I still have 5 minutes, we have 5 minutes? Am I allowed? Okay. I'm going to say a couple of things about civil law, just my perspective, and I think this will at least partially echo what Teresa was saying. In the civil law, there's one myth that Teresa did not disclaim, and that's the French Revolution as being so important for the civil law development. That was never true in Germany, the Netherlands, and many other European countries. So Germany never had any of this pretense that the French had around 1790 or 1800, that you could just write the code and that's it. I guess Prussia had it in 1770 something, but that was immediately recognized as a failure, and they never did it again. But the Germans never had this idea. Even in France, this subsided very, very quickly, this idea that you could do this. And let me show you this. Is it coming up? Well, eventually this will show up. So this is the Code Civil Annoté from 1819. It's Siri. It's basically a predecessor to the blue book that's lying somewhere there, but for the Code Civil. This is 1819, okay? This is 15 years after the code was adopted. And this is a commercial publication. So this is somebody who wants to make money, who sells this book. And how does this person make money? Not by printing the code, because the code is easy. Everybody has that thing. You print the code with annotations. How? You put other legislation and you put jurisprudence. You put the case law. So in 1819, Siri was already making money. There's even a prior edition. This is the first one I found. There's 1812, I think, is the first one he did. In 1812, 8 years after the code was published, Siri was starting to make money by publishing a book collecting the precedents. Why? Because the precedents obviously mattered in France even in 1812. People in 1819, because you need them. It's just, as Teresa said, it's impossible to... Even if you thought that all law follows from the statute, at least you need to know how it's being interpreted by the judges. Moreover, in France, already in the 19th century, and I think throughout the history of the civil law, entire areas of law, for the longest history, virtually all areas of law were developed by case law. So give you an example from newer times in France, 19th century France, the French tribunals developed administrative law. There was no statutory administrative law in France. The judges just developed it. The same thing happened in Germany. Then, and this may be a difference between, let's say, Germany and the United States, the German legislator saw fit to embody the law that had grown into a code. In the United States, we don't do that. Various reasons for that. In England, they are more prone to doing that, but even there, they don't really try to do that as much. The Germans, they like to, at some point, I guess, to simplify the scene, collect everything in a statute, so that then we have like a convenient starting point to write books like the ones that you are going around, and then you take it from there. It is of course possible that the details do matter, like this tendency I just mentioned to put things into a code once they have developed, or the way that the opinions are written. It is clearly the case that French opinions, for example, the highest French court, the Cour de Cassation, its opinions are literally one paragraph long, or perhaps two. They're almost impossible to read unless you are a real specialist. You certainly cannot situate them in the law unless you know a lot about that area of the law. You usually have to read a note by somebody who happens to know what the judges were talking about in the case, that will tell you what this case was really about. That's an interesting way how the French judges have tried to represent their decisions, but it should not be mistaken ever for them not paying attention to precedent. I mean, we know that they do, okay? We know that the judges, it's totally normal for them, and they write about it, and it's totally accepted that they operate by precedent all the time. So my bottom line is that as a first approximation, in the jurisdictions that I know, and those are the US, France, Germany, and the UK to some extent, precedent works just the same way in all four of them. And again, you tell me what Brazil does. It's the same thing. When the highest court decides a case, that's it. Everybody knows that that is the law. The highest court itself can and does overrule itself. It doesn't do it all that often, not because it's not allowed, but because it's embarrassing. You know, if you decide, if you overrule yourself too often, it's embarrassing. People lose trust in you as a judiciary, so you just don't do that. If you want to, you can, but you just don't do that all that often. Everybody, of course, spends most of their time interpreting statutes. That's just the same everywhere. We don't, for teaching students, we use cases, but then real life is statutes. And it seems to me that that's necessary for a functioning legal system. I can't imagine a system without precedent, as it's hard for me to imagine. I think the real question, let me tell you a question that I think is a boring one. I think it's the wrong question to ask, and then I'll tell you what I think is the right question to ask. The wrong question to ask is do judges make law in the abstract? My answer to that is, I don't even know what that question means, okay? And let me tell you more. In the 19th century, until the 19th century, common lawyers denied that judges make law. Yeah. Common lawyers denied, until the 19th century, that judges make law. Why? For exactly the same reason that the civil lawyers denied that judges make law, because it sounds, it's problematic, okay? We have that the king or the legislature, they make law, we know that. The judges, do they have the power to do that? And so the common lawyers, the English lawyers, they claimed, we don't make law. We just find the law. Now, like any serious person looking at this understands that that's nonsense, okay? Of course they make the law, but they didn't want to say it. And, today, I would say, in the common law world, by and large, that attitude has passed, except in confirmation hearings for the US Supreme Court, when the candidates have to pretend that they don't make law. But everywhere else, we accept that they make law. In some civil law jurisdictions, this is still a rhetorical issue. And you may read about, do we make law, do we not make law? I say, in France, for example, when I was a student in France, basically every course started, first half hour, was about the sources of law. And at the end of the sources of law, there would be like the jurisprudence. And then there would be some discussion, is it a source of law, is it not a source of law? And then we would spend the rest of the semester discussing the precedents. Okay, that's sort of like, okay. So that's why, so the real question is, like, how is precedent actually being used? And by being used, I don't just mean being respected. Because even if you want to respect precedent, there's still a question of how you do it. How do you interpret the precedent? And how do you even know about the precedent? And here I want to just add last couple of facts, because it relates to some of what Teresa said about the Brazilian courts. I think, Teresa, you said the Supreme Court hears 300 cases a year?
300,000 cases.
300,000?
Yes.
That's, okay, that makes more sense. 300,000.
300,000, yes.
300,000, okay, okay. So the US Supreme Court hears 80 cases a year. The English Supreme Court, I'm not 100% up to date, but it's also somewhere on the order of 100 cases per year. The French Cour de Cassation alone, and that's just for civil and criminal and commercial matters, hears 30,000 cases a year. Now, the French have miraculously figured out a way to deal with this. They have multiple chambers, and they have a system, they have some sort of system of communicating between the chambers and between the judges that allows them to prevent mostly contradictory opinions. So it sort of works. In Italy, they also hear 30,000 cases per year at the Supreme Court, but they have not figured out a way how to deal with this. And so I'm not a specialist in Italian law, but I'm being told, and I read, that in Italy, yes, precedent is very important. Everybody cites it. Everybody understands it's important. However, there's always contradictory precedents from the same court, even at the same year. So that's very good for a practice. I mean, I don't know, good, but it means that every side can cite their precedent. that is obviously a big problem. I mean, that's you have a problem for sure. You're guaranteed to have a problem. And so I think, talking about precedent, what I am really interested in is like, how do you people work with it, but also how is the system organized so that it is possible to work with the precedent? Because this flood of cases now with electronic databases, you know, I think in the United States we have also a couple of million of opinions that come out every year. What do you do with them? How does the system ensure that these things stay consistent and that people can use them consistently? So anyway, that's what I had to say about the topic.
Okay. So we're already running out of time, but I just wanted to make some quick considerations about the lectures here. First, you mentioned a very important footnote in the American case law. It came to my mind another one, which is footnote 4 in Caroline Products, where it deals with discrete and insular minorities, and is very important for the study of race discrimination in the U.S. And another consideration is that what Professor Holger does, this is real comparative law, because we tend to think that comparative law is just citing a foreign decision that we agree with. But this is not the case. You have to have good data. You have to control variables. And this is what Professor Holger is doing now. And it's a big endeavor, his work. With this, we won't have time for the questions, but I'll try to forward the questions which have the names on it to the professors so that you can answer afterwards. And with this...
Wait, we don't have we don't have time for questions?
Isn't the panel... okay, so please, Professor.
I teach at 1. But I am very happy to hang out as long as you... what's the next schedule item?
At 1.
At 1?
Yeah, and people have to have lunch. So.
Sure.
Não, melhor passa para eles primeiro, depois eu faço a pergunta, não? Tá? No, I would like to pose you a question. I've been thinking in the last years, in the last decade, to tell you the truth, about the changes of the law, development of the law, between commas. And the question that I would like to pose you is that if you have already thought about a possible answer to the question, when law should be changed through the labor of judges, and when law should be changed by the work of the legislative branch. And sometimes I think that there are fields of law where judges should be more active, as, for example, family law, fundamental rights, human rights, racism, and so on, human rights in general. And other fields where changes should come from the legislative, from the legislator, because predictability is a value more important in what concerns tax law, criminal law, than family law. So in family law, what is important is to make the right decision. And in tax law, the important is to make the same decision, because predictability is important. So I thought about that. I still don't know if it's the right path, the right way. What do you think about it?
That's a very deep question. I think I want to put first another consideration on the table, and that other consideration is the distribution of powers between the judiciary and the rest of the legal process. And so I thought where you were going to go with this question actually was something that is a very controversial point in the United States between different schools of thought about the law here. Should the judiciary basically be concerned with stability and deciding cases correctly according to what is the law, to the extent we can determine that? Or should the judiciary be a vector trying to push society in a particular direction? And, I think most of the time people who take the latter position do this from a perspective where they have a particular agenda that they would like to see pushed, and they think that the judiciary is going to be amenable to going in that direction. And since they are getting basically their way, they want their way. They may still have some concern that perhaps it's going to backfire, but that's what they want. Whereas I tend to think about it more abstractly. If the judiciary can go one way, they can go left, well, they can also go right, and just depends on who the judges are and what their preferences are and which direction it's going to go. So the protection of fundamental rights, for example, there's different ways how you can think about it. There's some fundamental rights where we all know what the content is, and certain forms of torture we all recognize as torture, and it's not a controversial position for the judiciary to enforce the prohibition of torture, and of course they should. But there are other fundamental rights. I mentioned abortion earlier. Should the judiciary be in the process of deducing a right to abortion from due process?
This example made me think about the question.
Process,
yes.
I think it depends. I think you could legitimately take the position that for various reasons the political process is too slow, that the rights of certain groups, in this case women, are not represented well in this process, and that therefore the judiciary, to the extent it can, should push in that direction. I think you might also take the position that either you might say this is undemocratic because this is not something that the legislature forgot, right? I mean, there are many things, and I think, the judiciary is definitely called upon to develop the laws in all those millions of corners that the legislature never has time for. They don't even realize that the problem exists. The case comes to you as a judge, you have to decide it now, and maybe your colleague has to decide it in 6 months again. The legislature, it's not even on their radar. They never hear about this stuff. So that the judiciary always has to do. But abortion is not something that the legislature has forgotten about. Okay, this is like, everybody knows that this is a big topic. Should the judiciary go ahead and push this point? Again, this, I think it's a hard point, because even if you were convinced that, for the reasons I mentioned, underrepresentation of certain interests or the right just being non-negotiable, you should, one also has to take into account that there can be a backlash. There can be a backlash against the court or the judiciary if one pushes this too far. So that's sort of what I thought you were, and I think it's a very important one. And then there's the question, let's forget about this distribution of powers between different branches. Let's just think about which areas of the law are ones where the judiciary can make the law. I think that to the extent that judicial opinions create the law, I'm not even sure that in tax law it's less important than in other areas, because in tax law, until the judges decide the question, nobody knows what the answer is. So it's actually good if the court puts its foot down and says, this is the line.
And don't change.
And then don't change. And then you wait until, of course. But I think stability, yes. And so I do think that there are some areas where predictability is
more
good,
important.
Is good. Predictability, of course, can also backfire because, for example, let's say in tax law, or in my area, corporate law, if the law is too predictable in the sense that people can figure out, if I tick these 3 boxes, then I will be allowed to do this, even though in a substantive sense this is a bad thing that I'm doing. The Delaware courts, U.S. corporate law is very concerned about preserving in this area of business law, where people plan in accordance to law, but the court is concerned about staying flexible enough to prevent the bad planning. The planning for abuse. That's something to keep in mind as well. I have a question for you as well.
Go ahead.
For all of you, really. Now that we've had, we've both spoken, and I think we mostly agree. So I'm wondering, from what I've told you about U.S. law, does Brazilian law operate the same way? Is it the case that once the Supreme Court decides a particular question, that's it, and everybody follows? Or is it, I hear laughter.
This is the answer. This is the answer. No, if you allow me to answer just in 2 sentences. We are Latins. We descend from Italians, Portuguese.
Germans are here as well?
Germans in Süden, in the south.
Yeah.
But the fact is that nobody obeys in a strict way decisions of our Supreme Courts. Not even they themselves. So we have the same problem that you said something about Italy.
Yeah.
Well, we have exactly the same problem. Once I remember that 2 Italian professors went to Curitiba, the city where I live in the south, and they began to say something about la Corte di Cassazione in Italy. And the people began to laugh. And I had to tell him something because he could think that they were laughing something negative, derogatory, and on the contrary, it was a kind of solidarity. Now we have the same problem. So, because of that, exactly because of that, this new civil procedural code created a sanction. Because for us, if we say, for Brazilian, you have to obey precedent, you have to respect precedent, and the judge is going to ask you, if I don't do that, what happens? If the answer is nothing, so I don't have to obey precedents. And so what this new system created, in fact, are some hypotheses, some cases where precedent has to be obeyed. Otherwise, there is the possibility there is a, how would I explain to a German, an absurd like that. But there is an action whose goal is to correct decisions, judicial decisions, which have not respected precedent, without making any distinguishing and so. Simply, I don't agree, or I ignore the precedent. So these decisions, they are corrected. Yeah. So these precedents, in our mind, they are binding, not the other. The other should be culturally binding. Yeah. That means that courts should understand that it's better for everyone, for society, for themselves, because they would work probably less if they respected their own precedents. So this is the case. This is the
If I may, I mean, I don't want to hold you longer than you want to say here, but I'm really interested in these questions. And the interesting thing about what you're describing is that when you said sanction, I thought you would say something like there's going to
prison.
be yes.
Death penalty.
Yes, something like that, you know.
Less than that.
Because the interesting thing is about, let's say, France, Germany, but also United States. If the judge disrespected the precedent, nothing would happen to them. I mean,
they obey.
There would be an appeal.
France.
There would be an appeal, and you know, if there's an appeal, the case would be overturned, but nothing would happen to the judge. Well, I would imagine, like, that certainly if a precedent of the appeals court, they would overturn the district.
No, in Brazil it wouldn't happen. Oh. I'm so very sorry to tell you that. Dirty laundry should be.
I'm really surprised.
But it's true, isn't it? It's true, because even the STJ, even one of our superior courts, two of them, in fact, they have all the possibilities. It's like Quitanda, how do you say that in
like an open market.
Yes, you have peas, you have apples, you have beans, you have bananas. You can find a precedent, yes. So it's to put an end to the chaos. That is why I always say to my students, what is happening now in Brazil has absolutely nothing to do with common law. Right. It's just a way to stop the chaos and the total lack of predictability.
Right. But, I mean, so then the question is that I have
very sad.
To you and everybody, if that is the situation, in some sense, it's almost like the culture of precedent, not the rule of precedent, but the culture of precedent seems to be not present. And then the question is, can one change the culture, or to the extent that that culture is present? I mean, like,
Yes.
you are all judges. I've seen you. You're very conscientious. I'm sure you understand the value of consistency. There must be other issues that prevent that culture from emerging. Like, I could imagine if, for example, there were a cultural or ideological conflict between the highest court and the lowest courts, that the lowest courts might rebel or something like. I mean, what is it that stops this consistency?
What do you think?
May I just make an observation? There's another problem in Brazil which has to do with the dynamics of judicial decision making in the higher courts. Because here in the US, you know what the holding is when the Supreme Court decides. Right. But in Brazil, actually, each of the justices has his own opinion, and then you have to decide which of the opinions is the actual holding of the case. And when the Supreme Court decides like 300,000 cases a year, it's not very difficult to find one precedent that is favorable to your own interests. Because here in the US, there's no actual sanction to judges that don't follow precedents, right? I remember that in Obergefell, the same-sex marriage case here, one state judge refused to apply the precedent, and he was administratively prosecuted. But this is not very common here too, right?
Yeah, I mean, if you go too far, and that could happen to you also in France or Germany, it's called like bending the law. Like if you were to affirmatively bend the law, and actually that would happen if you were to disobey a decision of the Constitution.
Openly.
In the Constitutional Court. And like this would be the equivalent of Obergefell. We have the same sanction, but that is extremely rare and only applies in particular situations. And I will say one last thing, the fact that one decision has multiple opinions, that actually is standard in the UK. So the English courts have always decided cases by individual opinions. There may be 3 judges, but each judge writes their own opinion. And in principle, the same issue arises, that when you have to deal with this precedent, well, you ask, well, which one? There's like 3 of them. Hopefully they are sort of saying the same thing, in which case you know what they stand for, but sometimes they don't. I think, to me, what's really striking is the number, 300,000 cases, Of course, how can you...
They have no time.
How can they do it? How can others trying to work with those opinions do it? It's like total overload, right?
Okay, so now we're completely out of time. I would like to thank our panelists. Please, one round of applause for them.
Thank you.
It was simply amazing.